Judgment in the appeals VA Nigeria and PE Cameroon against the Secretary of State for the Home Department.
The respondents were each served with a deportation order after unsuccessful appeals on human rights and asylum grounds against the decision to deport them. They both unsuccessfully made further submissions to the Secretary of State in an attempt to have the order revoked. They then applied to judicially review the decision not to revoke the deportation order, maintaining that their removal from the United Kingdom would be in breach of their human rights. The issue in these appeals is whether, once a claimant has had his appeal against a decision of the Secretary of State determined, he can make another appeal in country on the same grounds as those which were rejected on the earlier occasion. The Secretary of State argued that a repetitive claim did not fall within Section 92(4)(a) of the Nationality, Immigration and Asylum Act 2002, which provides for an in-country appeal where the claimant has made an asylum claim or a human rights claim whilst in the United Kingdom. He argued that where, as in the case of one of the appellants, further representations have not been advanced as a fresh claim as defined under Rule 353 of the immigration rules, or as in the other's case have not been accepted as such by the Secretary of State, they can only be considered out of country and that there is no obstacle to the deportations. The Supreme Court does not accept that argument. The appeals by the Secretary of State are dismissed by a majority of 4-1. A claim for asylum which has been rejected should be allowed to proceed to appeal in country under Sections 82 and 92 of the 2002 Act, unless it has been certified as clearly unfounded under Section 94 or excluded under Section 96. This should be so whether or not the Secretary of State has accepted it as a fresh claim. There is a dissenting opinion by Lady Hale.
Judgment in the appeals, the Queen on the application of A against the London Borough of Croydon and the Queen on the application of M against the London Borough of Lambeth.
Local authorities owe a variety of duties towards children in need, who may include children who arrive unaccompanied in this country and claim asylum. They may be entitled to accommodation and other help which is different from and more suitable than the help which is available for adult asylum seekers. So disputes can arise about whether a person is or is not a child. The court heard 2 cases, but there are many others where the same issue arises. Who decides whether or not a person is a child? Is it the local authority to whom the case is referred by the UK Borders Agency? Or, if the issue remains disputed, is it to be resolved by a court? The Supreme Court unanimously decided that the question was ultimately one of fact for a court to decide. There was a second issue in the case, whether the duty to accommodate certain children gives them a civil right, which under Article 6 of the European Convention on Human Rights must be determined by a fair trial before an independent and impartial tribunal. As the appellants had won on the first issue, the court did not need to decide this important question, but it is relevant across the whole field of welfare services and is currently before the court in another case. Accordingly, the court has allowed these appeals.
The court will now adjourn.